Now, I'll give you two examples. I think in the PPT also, there are two examples of pathetic, probably, really inartistic. I have taken the worst examples. I'm sure there may not be some of the arbitration clauses which would be like that. So
Mm.
one is that all disputes arising out of the present contract shall be settled by way of arbitration. Now, to a layman, to a common man, this may seem to be a perfect arbitration clause,
Mm.
that the intention is clear, that if disputes will arise, we will go for arbitration.
Mm.
But the problem is that this arbitration clause do not have the prerequisites or the essential elements of an
Mm.
arbitration clause. So merely on the basis of this arbitration clause, you cannot really know who is going to appoint the arbitrator, what would be the language of the arbitration, and how many arbitrators are going to be appointed, what is the seat of arbitration, which law is applicable to the arbitration. None of that has been answered.
Mm.
Merely, it has been mentioned that disputes will be resolved by arbitration.
Yes.
I think now, if you look at it like that, if you try to give it a true meaning, it is next to impossible to ascertain as to how to get answers to these questions.
Yeah.
Now, look at the other one, which has very nicely been put in the PPT. Okay, so this is a relatively detailed arbitration clause, but look at how interestingly, some blanks have been left. So this says any controversy under this contract shall be referred to arbitration under the rules of dash. Parties will mutually decide the arbitration, and in case of disagreement, the arbitrators chosen by the parties. It is argued that the dispute shall be submitted to the Court of Delhi. It should be agreed anyway. I know sometimes the English can also be like that in arbitration clause. So if you look at this arbitration clause, the problem is firstly, we don't know which rules the clause is referring to. It's
Mm.
now to get the idea to this, I think this will take forever to ascertain what was the intention of the parties. And if you read further, it is talking about disagreement between the arbitrators. Now,
Mm.
what will happen if there is a disagreement?
Mm.
Initially, it says mutually decide the arbitrator, and in case of disagreement, I don't know. This doesn't make sense.
Mm.
And if you look at the last and the most interesting blunder, it
Mm.
is dispute shall be submitted to the Court of Delhi. Now, since the very beginning, I could understand that they're talking about some arbitration to happen to resolve the disputes.
Mm.
All of a sudden, they're talking about the courts of Delhi.
Mm.
So it is not clear whether they want arbitration or they want to go to the court of law. So
Exactly.
another reason for another party, whoever wants to resist the arbitration, to say that, look, the intention was not to arbitrate, the intention was to go to the court. So I think that it's extraordinarily important for parties to know how not to draft an arbitration clause
Mm.
rather than knowing how to draft an arbitration clause, because I mean, these blunders have to be avoided. And these are some blunders which can actually, delay the arbitration proceedings to such extent that the parties will eventually be disappointed and will be left frustrated.